Oh man, good for you. I don't have to be I'm not your nanny. You're good. Okay, fine. I get to go find some real criminals. In court, some things that we can do in court. First of all, don't ever accuse yourself. If you go in there, and this is one of the key things I found when we were with Rob in court, we asked the prosecutor, will you please identify the accused party? She asked us, are you going to be taking part in this? She almost said charade. She said, are you going to be taking part in this? I said, will you please identify the accused party? Oh. Just walked away. We got it on the record that Robert Scott Christie was in the courtroom, but the accused was not. And that was good enough for us. They will ask you, what's your name? It's none of your business unless and until you've accused me. They want you to give the name. They say, okay, you're the accused. Come on up here. You're stepping right into it. You can say, I'm not giving you any name whatsoever unless somebody accuses me. So, do you know my name? No? Well, then clearly I can't be an accused party, can I? You step right into it. They will refuse to identify you as an accused party for any statutory or summary action. They can't and won't do it because it's only against the fiction. It exists in association with you. That association must be lawful, and therefore it must be voluntary on your part. They will ask you, what's your name? Okay, Mr. Menard, please step forward. You're faced with these charges. Oh, well, yeah, apparently. Okay, you just accused yourself. A friend of mine, Greg Calcutta, he held up his summons. He's standing there. What's your name? I'm here to deal with this number. Well, I need your name. I'm here to deal with this number. And that's all he did. Stood his ground. I'm here to deal with this number. Okay, we can't. They never called his name. They never did anything. And then it just got wiped. It was gone. Another tactic that works very well in court, and I saw this, I thought it was the most beautiful thing in the world. Lutz, Brian Lutz, L-U-T-E-S. You can look it up if you want. He was charged under the Income Tax Act with failure to file. It's not you who has to pay this income tax. It's your person, of course. It's your account that you set up with your social insurance number. This means they have to create joinder between you and this number. If you send them a document saying, hi, my social insurance number is 47, you've used it, you're in it. He never allowed them to create any joinder between the two. But when we went up in court, we go up in court and, little aside, I'm testifying. They put my hand on the Bible. They say, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I went, no. And the judge looks at me. I said, I'm sorry, good sir, but I can't swear to tell the whole truth. I don't know the whole truth. If I did, my name would be in this good book and not my hand upon it. I said, I don't think anyone knows the whole truth. I think if anyone did, I think they're insane. But I will promise to speak to you the truth that I know, and I won't leave anything out. But that's about all I can do for you, good sir. Okay, that's good enough for me. At this point, what they'll try to do is they'll try to take that Bible right away from you. Don't let them. Keep it. And when they say, okay, well, according to Section 38 of the Income Tax Act, you go, what page are we on? Oh, I swore on this, Your Honor. You're not holding me to anything else. This is the one we're using. You want me to swear on the Income Tax Act? Try bringing that up. So you can do that. That Bible is very powerful. You don't have to let it go. And this is what they give you a shield. They take it right away from you. And they can say, oh, well, we gave him a shield, but he lost it. That Bible is your protection. Hold it up between them. Stay away. Stay away. If prior to going into court you have served a notice of understanding and intent and a claim of right, and this claim of right is you're claiming the right to serve a bill upon anyone who would possibly give you any orders, when you go in there and the judge tries giving you an order, I'm looking for orders. I'm here to fill your orders because I got a big book of bills right here. Go in there with bills already made. Whatever order they give you, multiply, throw a zero on it. There you go.
How long do you have before you can produce that bill?
Right then, immediately.
But you have some time? You have 2 days, 3 days? Or?
Well, for the, I imagine you would be able to present them a bill, but normally you present a bill immediately upon service or cessation of services, do you not? Like think of a restaurant. You go into a restaurant, even if it's a fast food restaurant, you're giving your order, you're liable for the bill, you pay that bill, the order is fulfilled. If you go to a regular restaurant, you can place an order and they're trusting you. They could, if they wanted, demand payment for that prior to fulfilling. Yeah, they could if they wanted, but they're just being nice because they want tips. Hey, Clint was in there. So, recognize that them giving you orders isn't necessarily a bad thing. And the moment you hit them with one bill for one order, I guarantee you they are going to go way out of their way to never give you another order. And a very little known fact in Canada, because Canada is a common law jurisdiction, we're all equal. Nobody has the right to enforce adjudication services upon you. I went and I listened to Beverly McLaughlin, the Chief Justice of the Supreme Court of Canada. She stated very clearly, right on the record, no one can provide adjudication services without the consent of both parties to the adjudication. They need your consent. It's a transaction of a security interest. We're all equal. They might be a little bit sneakier, but that doesn't make them morally better than you so that they can order you around and dictate your actions. Therefore, you always have the right to respectfully decline to accept their judgment. And the Canadian government did this. The first time I saw it, the Canadian government, we respectfully declined to accept this court's judgment, and you can do that too. And okay, fine, that was my thing. Because bear in mind, there is no real society. If you read these judgments, they say, well, in a free and just society, yeah, name it. They all talk in hypotheticals, and if you're not a member of the Law Society, you're not bound by these words. All these lawyers are. If you go into court, bring the Law and Equity Act. They hate that. You can bring that, show it to them, and say, yep, this is the Law and Equity Act. I intend to use it. I'm going to find my remedy, because no matter what you say, I've got 3 days to say no. They don't like this. And when we went in with Rob, and I've gone in with a couple of people, and I tried to tell the JP, well, we're going to use Law and Equity. No Law and Equity Act in here. I'm not hearing anything about Equity and Law Act or anything like this. And he was just so shooken by that. And the reason is because it's the monopoly bat. You can just clear his entire bench with it, and he ends up liable. Again, they're human beings. They're in a common law jurisdiction. They're liable too. They aren't given full, complete freedom from liability for their actions. If they're committing a fraud, one of the remedies you have as a plaintiff is to bring action against them. You have all the remedy that would have been available to you in 1876. This means you have a right to bring action against them as well. Ask them as well. Are you offering me a transaction of a security interest? Get this on the record. Label it as a security interest. Label it as a transaction. Even if they ask for your name, a security interest can be an intangible. Anything that generates an obligation or a duty to perform is a security interest. Your name could be viewed as one. If a cop asks you, what's your name? That's an intangible security interest, actually, and why do you want it? What am I getting in return? Judges hate it when you ask them, is this a transaction of a security interest? If they say no, you can just walk out. If they say yes, you've got them right over the barrel. One of the things they're doing when you get in court, if they're acting upon your legal entity, upon your legal fiction, you come up and if you answer for this name, they are assuming that you are acting as surety for the charged party, for the accused. That's why you're moving. That's why you're acting. Go in there and say, even if you have to give them your name, whatever, just tell them, equality before and under the law is mandatory. You and me, we're equal. I don't know why you're sitting up there, Judgy Wudgy. Equality before the law is mandatory. I'm competent to administrate my own affairs. I do not consent to this transaction. He has no power after that. He can't do anything. He'll try to railroad you. He'll try to get you to appear to change your position and opinion. Stick to your position. Stick to your guns over and over. Tell them right off. Tell them, I am not surety for the accused, although our names are very familiar. Oh, really? What's your name? Why do you care? I'm not the accused and I'm not surety. That's all you need to know. I'm just here as a member of the public observing. The big one, ask them for their oath and their bond information. They're an officer of the court. If they're an officer, they're holding office. Offices have oaths. Ask them to put their oath on the record and their bond information. The bond information is who issued the bond, what's the value of that bond, and who is holding it in trust for redemption. The bond is a piece of paper. Essentially what they got to do is they have to act on their bond. They're standing on a piece of paper which is worth $1 million, and they can't step off that paper. They cannot operate outside of the realm of that bond. If they do, you get to say, hey, look, someone abandoned $1 million. Thank you very much. You take this bond. If you get your hands on that actual bond, you take the original to the issuing agency. It's a check for that amount. They have to honor it. That's what the bond is for. If they don't have that, if they don't have the oath and the bond, and they don't want to put it clearly on the record, you can tell them you're not holding office lawfully. You can also give them their oath. I'll tell you what your oath is then if you don't want to enter it in the record. You've had success in this, have you not, Mary? Where you you put their oath on the record?
Yeah, I accept their oath into the matter.
So poke them on that. The big trick is what I found. It's a bit of work because you got to find the path where you're loving and you're gentle and you're respectful to their office, but at the same time you are just not going to take any shit from